May I, my lord?
Yes.
My lord, I beg to mention item number 6 on behalf of leading counsel for the petitioner S. Chaudhary. Lordship, this matter may be listed after vacation, my lord, as he is out of station.
Lordship, you have received CD in this matter. There may be a direction for updated CD in this case.
Mr.
H. Takum,
When do you want, you said?
after vacation.
Okay. H. Takum appearing on behalf of the Gogoi, line counsel for the petitioner, praise for listing this matter after vacation. The prayer is allowed. List this matter after vacation on the date to be fixed by the registry staff. The Lanet PP shall also produce the updated. Sorry, the Lanet ADPP shall also produce the updated CD of the updated CD on the next date. Okay.
Obliged, my lord.
Mention for listing a BA lordship.
Hmm?
Mention for listing a BA lordship, regular bail, charge-sheeted matter lordship.
Oh. When?
Today itself if possible, or on then 1 July. If possible, today itself.
Bail application, regular.
Regular bail.
What is the offense in both?
302.
302.
Yes, lordship.
You have already filed
Yes, lordship. I have already deposited.
as a last matter.
Okay, lordship.
Okay.
Allah.
If it reaches, otherwise it will be listed next day. Yes. Yes, I mean, my lord. Yeah. And I am impugning, my lord, two orders, my lord. Order dated 25/2024 and 21/5/2020, whereby, my lord, learned trial court, my lord, without giving me a pierce as a cross examination, the prosecution witness, my lord, has discharged the witness and closed the evidence of the witness, my lord. Now, before coming to impugn order, my lord, I will kindly invite my lord, my lord. This, page number 25, my lord. I will start with page number 25. 25, my lord. This is my lord, order dated 18/5/2024, my lord. By this order, SAS has framed against me, my lord. My lord will kindly turn to page number 26, my lord. Next page, my lord. Para 7, my lord. Last, my lord. SAS was framed, my lord, on that day, my lord, and fixed the case on 21/5/2024. Examination of witness named is such and such, my lord. Accordingly, as my lord has seen my case of petition 21, my lord, 21/5/2024, my lord. Next day, on that day, I appear, my lord, with my counsel, my lord. My lord will kindly say page note 27. This is the cause list of that day, my lord. This case was not listed, my lord. My case, 27. This is cause list of the not listed, my lord. But then, my lord, according, my lord, the case was fixed. But the case was fixed. 27, page 26, my lord, will see, my lord. Fixed the case on 21/5/2024, my lord. Down below, my lord. Para 7, my lord. Fixed on 21. 21, my lord. 21/5. Now, this is 27, page note 27, my lord. That is 20. The cause list for 20? For 20, my lord. And yes. 21 at page note 28, my lord. Yes. Case was, sorry, my lord. At page note 26, my lord. Case was fixed at para 6 for some witness 20 and some witness 21, my lord. That is in para 6 and 7, my lord. Now, page number 27 is the cause list of 20, my lord. My case is not listed, my lord. At page number 27 also, my lord. This case was not listed, my lord. However, my lord, I do consider, later on, my lord, I was informed, my lord. The case was, this case was fixed on, that is fixed on, my lord, 21/6, my lord. I was informed, my lord. Shortly informed, my lord. But then, my lord, when that case was fixed on 21, my lord, at 21, my lord, 6, my lord.
No, no, by this order, this is what the order was.
No,
was right?
no, my lord. This was as
What
per
you want to show here?
26, my lord, as part of page note 26, case was fixed on 25, my lord. But on 21, 20 and 21, that was not listed, my lord. But subsequently, I was informed by the registry, my lord, that case was fixed on 21, 6, my lord.
21?
21, 6, my lord. 21, June. Instead of May, my lord, it was fixed on June, my lord. The order was on 21, 5, my lord. On 21, 5, May, I appear, my lord, case was not listed. Later on, my lord, through registry, I came to know that it will be fixed on 21, 6, my lord. Not 21, 6, my lord. Now, accordingly, I informed my council, my lord, who is not the station council, my lord. My council is of out station, my lord, from Itanagar, Nagaland, my lord. Now, on that day, my lord, what happened, my lord? My lord, kindly turn to page number 31, my lord. This is the order dated 20. This is the order of impugn order, my lord. 31, page number 31.
31,
31, my lord.
impugn order.
My lord, one of the impugn order, my lord. Today, present case is fixed for appearance of the accused person and examination prosecuting witness. The accused person named is present. Learned counsel such and such for the accused is absent, my lord. He's out of station advocate, my lord. He's returned. The witness, namely victim such and such are present, and they are examined as PW 1 to 4 by the prosecution. Learned counsel for the accused has not turned up, my lord, for the cross examination of the witness. The accused is asked to engage any other
Let us
advocate.
see the record. Let us see the record. Issue notice, will issue notice.
My lord, my humble submission, my lord, is my lord, next date is on this case, my lord, is on 1, my lord,
For what?
for prosecution witness, my lord. What are other prosecution witness?
Let the other witnesses be recorded in the meantime. You want these witnesses to be recalled
Recall, my lord.
for cross-examination.
Cross examination, my lord.
Yes.
Lordship, as per the order, Lordship, they have
Yes, it
not,
appears that on May only it was fixed, May 2021,
Lordship,
May 21, 20
Lordship.
and 21. But then it appears that the examination of the witnesses was done on 26 June
20, 20, yes,
20 and
Lordship.
21.
Lordship.
And then how, you see, the matter was fixed on May only, but it was verbally informed.
Lordship.
But to that
Verbally-
extent, my lord, I am in fear, my lord. But my issue, my lord,
But in that case, opportunity should be given.
my lord, fear, my lord, here, what happened, my lord, you kindly see para to my lord.
Whether on 20 and 21, any order, so let us, we have to receive the record.
Amen.
Okay.
Lordship, yes, Lordship, the records to be needed, Lordship. So,
Need
all
to see the record only.
Lordship.
So no date was fixed in the meantime, in between. On 20 May and 21 May, no order was passed.
No order passed, my lord. I was informed but I was informed, my lord. I considered, I was informed, my lord. Accordingly, on that day, I appear, my lord. My lord will see, my lord.
On 20,
I appear,
on
my
which date?
lord. 20, I appear, my lord. 26, my lord. Page 30, my lord.
Okay, then what happened?
I appear,
Why
my
you
lord.
did not cross-examine then?
My counsel, my lord, he's out of station advocate, my lord. And that day he fell ill, my lord. Accordingly, he could not appear, my lord. Now, I was directed on that moment itself, either I need to engage legal counsel or any other advocate and need to cross-examination on that day itself, my lord.
Yes.
So I declare, my lord, it's not possible as I already I have engaged a private lawyer and he is suffering, my lord. He could not appear.
When you were informed that the case is fixed not on 20 May, but on 20 June, when you were informed?
20, that, my lord, I consider.
On 20 May only?
No, not prior to that, my
Why?
lord. Prior to that, my lord, that's why I appear, my lord. I do that part I concede, my lord. Though, my lord, case was wrongly on that day fixed, they not listed, but then I was informed, my lord. But in my issue before your lordship is, my lord. Yes, I was informed. But my counsel, my lord.
When you were informed that the case is fixed on 20 and 21 June, when you were informed?
Prior to the date, my lord. Exact date I
Okay.
forgot, my lord. Prior to
You got
that,
the
my
prior information.
information
Okay,
was
then
there.
why you did not appear?
My lord, my counsel, my lord, was
So what, in a criminal case, because you say that when the witnesses have already been informed,
My lord.
witness has been called, you know that they will come.
what is you, my lord?
And then,
But then, my lord, my counsel, my lord, engaged counsel, my lord. I have already engaged one counsel already, my lord. At the at that moment,
No, it's difficult. If you were informed, you were given an option also to cross-examination or to engage anyone.
anyone, my
You
lord.
deliberately, you remain absent.
That way, my lord, my lord, my lord.
Because the summons were already issued to the witnesses.
Yes, my lord. True.
Witnesses normally are from, this is case of which,
Hello.
which district?
Yes, my lord. I was informed. I'm not. I have no quarrel on that, my lord.
That way it will be difficult.
My
Because
issues-
after fixing, if you just ask for adjournment,
My lord.
that will be a difficult.
But
And then you are present.
I was
You were
present.
given the judges ask you also to engage any counsel.
Any counsel, my
Also, they are also ready to provide you the legal aid counsel also.
That, my lord.
And then,
That issue, my lord.
then what do you want? What more you want?
That is the issue. I'm putting issue before my lordship, my lord.
Hmm.
Now here is a case, my lord, criminal case, my
Now you see, on the date fixed by the court,
lord.
how many witnesses were examined?
On
6-7 witnesses, maybe
on that on the 2 days, my lord, 7 witnesses, my lord.
7 witnesses.
My
You
lord.
see, and then you very well knew
My
that
lord.
these 7 witnesses will come from no far away place,
My lord.
and then you remain absent. How do you expect the judge to call again and again? And how do you expect these witnesses, those who the witnesses are not being paid here in Arunachal Pradesh?
My lord will kindly appreciate, my lord. I did not remain. I was present, my lord. Yes, I present, my lord. For situation, my lord, I was out of
At
control.
at your choice, it can't be.
No, my lord. Situation, my lord is kindly appreciate the situation, my lord. Accused in terms of court or yes, information accused as present, my lord. But his engaged counsel, my lord,
Accused is bound to be present in criminal case in all the days.
my lord.
But he need to engage the advocate also to conduct a case, to defend his case.
Yes, my lord.
And he knew very well that these much of witnesses are coming on that day.
Yes, my lord. True.
That,
That way, my lord.
what do you want?
My lord, kindly appreciate this situation. My lord, kindly appreciate this situation, my lord. All
Did you make an application before the trial court?
No.
That you are ready to bear with the expense of the witnesses?
no, my lord.
You
Here
made an
also today,
application there?
today also, my lord. I will bear the cost, my lord. I'm not saying, my lord, free of cost.
See,
I'm ready to bear the cost, my lord.
that technique is trouble. Because you want that these witnesses should not appear.
No, my lord.
That will not work.
No, my lord. My lord, kindly appreciate the situation, my lord. Accused was there, my lord. But then his engaged counsel, my lord, private engaged counsel, my lord, due to the illness, my lord, could not appear before the court, my lord. Now, accused made a specific prayer before the court, my lord, as his accused suffering from some alignment, my lord. He need to want to read the pros, my lord.
No, because nowadays this kind of a tactic played by the defense counsel. If you knew that if you are really knew that the counsel is not present, could have informed earlier to the staff also, so that the staff could call them, and then no, this time they are going to seek for adjournment. You don't need to come next time. So that information you could have at least given.
No, truly, my lord. My lord, but here is a different situation, my lord. Now, my lord will kindly say medical.
Now, even the record is being called also then. Admittedly, you remain absent.
I was present, my lord.
Your counsel.
My lord. But his absent, my lord, with some reason, my lord, not that on his own wish, my lord. He was suffering, my lord. My lord, this person, my lord, engaged counsel, my lord, he has a history of hypertension, my lord. That on that day also, my lord, my lord, can you turn to page number 29, my lord, in section number 3, my lord.
Oh, yes, what do you want? Record to be called or?
Lordship, a record may be called lordship.
Why?
Lordship, because lordship, at this stage, lordship, if
At-
interim is given,
Admitting that
Lordship.
he had a prior knowledge.
lordship.
Hmm.
Here, lordship, here, moreover, lordship, here in this order is reflected that no application for adjournment was sought by the accused counsel, lordship. At
You
that
did not
date
file
also.
application also.
No.
No,
Application for adjournment.
no,
And then if you know that he is out of station, your counsel is out of station, the other juniors are there, were there.
my lord,
So
Kindly-
could have informed, make an application, could have made an application.
my lord, have a look at page number 29, my lord. Page number 29, my lord.
What is that?
This is the medical, what was the medical condition of the council, engaged council, my lord? Page number 29, my lord.
This is private.
No, my lord, this is, my lord, he's at page number 30, my lord.
Showing the, when this was. Hmm? Where? This is? You knew it from the very beginning that he is not in the station, would have informed and submit an application that on that day can't do.
Yes, my lord. That,
Because on the consent of the parties only, the next date used to be fixed.
yes, my lord. That, my lord.
And then the witnesses also, how many witnesses will be able to examine? Considering that only the witnesses are being summoned.
Yes, my lord. That part, my lord, there is some.
That cannot be trial, huh? That way the trial of the cases are delayed because of these kind of activities.
No, my lord. In this case, my lord, cognizance, my lord, was taken on, my lord.
So
29
want to
on.
file objection or so because who are the listeners?
My lord will kindly appreciate a situation, my lord. Now, this is a, my lord, criminal case, my lord, under POSCO, my lord.
So
POSCO, my lord. Now, my lord, now punishment, my lord, will know is very rigorous, my lord.
then
In such situation, my lord, at least, my lord, at the direction of the trial court, my lord, when I inform, my lord, my counsel is suffering, my lord, from illness, my lord. At the moment, my lord, engaging a advocate and make to him pro examination, my lord, my humble, my lord, submission, my lord, ultimately fair trial, my lord, need to be given to me, my lord. I am not saying, my lord, there was no fault on my part, my lord. Yes, there may be some fault, my lord. That's why, my lord, I already request make a prayer or a prayer, my lord, to the learned court below to give me a chance. I will ready to pay the cost also, my lord. There, I ready to pay the cost of the witness also. Therefore, my lord, yes, my lord,
witnesses are basically from where?
from my lord, SEPA, my lord. No, my. So, today, my lord, my humble submission would be, my lord, as my lord, I have invoked the, my lord, in his jurisdiction 482, my lord. My lord, kind appreciate. Ultimately, yes, my lord, there may be some part on assuming, my lord, there is a fault on the part of the council of the accused, my lord. My humble submission, my lord will not overlook the fundamental principle of fair trial to the accused, my lord, and direct the learned court below with course, my lord, let the I may be course again those with this, my lord.
To make that prayer, you have to be very fair.
Yes, my lord, I was fair.
You are causing trouble to the
No, my lord,
witness in the POCSO Act.
yes, my lord, here is my case. This is
Lordship, this is POCSO matter, then the lordship, other party may be implicated, lordship. Because the revision, criminal revision petition and all the proceeding, lordship, in the especially POCSO matters, lordship, both the parties should be heard.
no, if we enter into those things, my lord will need to state a proceeding of trial court, my lord. I also don't want to make such prayer, my lord, as I don't want to also stay of this case, my lord. Let the case be proceeded, my lord.
This amount to causing harassment to the accused, the victim side, you see, in the POCSO case.
Oh, no, my lord. My lord, kindly appreciate the other aspect of
Witnesses. That is what the court wanted to avoid. And then
my lord will kindly appreciate the thing, my lord.
you want that the witness, the victim, including the victim, to appear in the court again and again.
No, my lord. No, my lord will kindly.
That becomes difficult. No.
No, my lord, kindly appreciate, my lord. This, my lord, illness of the engaged counsel, my lord, is not under the control of the accused, my lord. he was having some illness, my lord, and he is out station advocate, my lord. And it not the learned court below, my lord. Also, I do believe, my lord, my counterside also note this engaged counsel, my lord. He has a history of this hypertension, my lord. The illness of my lord, for the illness of the engaged counsel, my lord, if my lord, the very basic right, my lord, to write exam the pros, my lord, will be not allowed to violate those under 482, my lord. My humble submission, my lord.
So the same day, probably the victim were also examined.
Examine, my lord. My
see,
lord will kindly see at
no.
page number.
It was deliberate, it appears.
No, my lord.
How,
My lord will see, my lord, 26, my lord. Page number 30, my lord. This is past impugner 20, page number 30, my lord. Para 2, my lord. I am reading, my lord. The witness named is, he is the victim, my lord.
20 is
30, my lord. 30, my lord.
31.
The witness, namely, my lord, this is a namely victim, my lord, no, are present and they are examined as a PWN by the evaluation.
We have to see. So, do you have the records of the addresses of all these
Lordship, no, lordship.
witnesses? You have the records where the witnesses list, have you annexed?
No, my lord, I have not, my lord.
Some of them probably seems to be from outside also.
No, my lord. Background of the case, my lord. This is my lord, my wife only, my lord. This is my lord. This victim and I, my lord, enter into marriage, my lord. We have 2 children also, my lord. Now after we enter into marriage in the year 2020, my lord. Now
This is from Arunachal only.
Arunachal, my lord. From Sepa, my lord.
This name from outside also. So accordingly, even if you have.
No,
to
my
say
lord. This is from Sepa only, my lord. West Karachi, my lord.
Ram, Arvind, all this.
Yes,
from
Seda, my
Sepa.
lord. This is Seda is my lord. Ram Seda, my lord. No, my lord. They are native of the East Kameng district, my lord, or from East Kameng. This is this victim, my lord. Victim is my wife, my lord. In 2020, my lord, we have 2 child, my lord. Now in 2024, my lord, some discord happened, my
Victim
lord.
is your wife?
Wife, my lord. My lord, you kindly see it in
So she was minor.
my lord. When we enter in page number 25, my lord. 25, my lord. From part 3, my lord, it will 11, my lord. I have carefully perused the case record, including the charge sheet, statement witness recorded by IO 161 as well recorded by magistrate under 165 CRPC. Also perused the birth certificate of the victim girl. It is observed that the date of birth of the victim girl as it is reflected on birth certificate of victim is 1 on 28 2006 and LS offense took place during November 2020.
Just a minute. So thereafter, you did not make any application before the trial court for allowing you to cross-examine the witnesses.
No,
You
my
did not make.
Well,
Could have made.
No, my lord.
Why you did not?
My humble understanding of law, my lord, is my lord. Ultimately, my lord, no, my lord, criminal court, my lord, has no review power, my lord. Here in this case, my lord, he directly discharged those witnesses, my lord. Now, if I want to make application, my lord, under 311, my lord, it is not allowed, my lord. My humble understanding of the 3111, my lord, it is on.
Because you said that on that day, the advocate were not present. Only the accused was present.
Those all issues, my lord. I'm submitting before your lordship, my lord. That all were available before the learned court below, my lord. On those when this order was passed, my lord, when the witnesses, my lord, were examined, discharged, my lord. The fake, my lord. My counsel is suffering, my lord. I don't want.
Right. You said that your counsel was not present.
My lord.
Only the accused was present.
My lord.
So you have a reason.
Yes,
an
ma'am.
application.
Yeah.
That the counsel was not present.
Yes, my lord. Orally, I submitted, my lord, though there is no written application, my lord, by the accused, my lord. Yes, my lord.
Why already?
My lord, that's why, my lord, my engaged counsel was from outside, my lord. I is accused, my lord.
How do you expect to pass an order on your oral submission?
My lord will, that's why my lord will look into the other aspect of the case, my lord. The accused was present, my lord. Now he is not a well acquainted with the
Heard, Mr.
procedural law, my lord.
L. Parme, not a counsel for the petitioner. So I've also heard Ms. L. Hage, learned additional PP, state of April, staff. Para. The applicant is agreed, and the applicant filed this petition under 482 of the CRPC. Waiting for setting aside and quasi. The part of order,
My lord, only part is the examination part. I have no grievances, my lord. Only part, my lord, where the witness, my lord, has been closed, my lord. Again, discharge and closed, my lord. That part only, my lord, I have grievances, my lord.
not the other part.
No, other part, I have no objection, my lord. That is part of the procedure, my lord. I have no objection. My lord. Only not allowing me, giving me a chance, my lord, to cross examination. That part I have agreed, my lord.
Okay, then the petitioner is agreed by part of the order dated 2024 and 21/6/2024 passed by the Learned Special Court, POCSO Act. Where have you given the number of the case number? Where is the case number?
Case number, my lord, this is POSCO case number 3 of today.
POCSO case number, huh? 3/2024, arising out of SEPA WPS case number 03/2024 under section 378, 326, 506 IPC, read with section 6 of POCSO Act. Whereby the Learned Trial Court, after examination of the prosecution witnesses, prosecution witness number, how many you said?
1 to
One
7,
to
my lord.
7.
1 to 7, my lord.
On 20, how many?
4, my lord.
Okay, 1 to 4.
4. And on 21, 5
On
to 7.
20,
Oh, 5 to 7.
6, 24, and 5 to 7
My lord, 21, my lord.
on 21/6/2024. As discharged the witnesses without giving an opportunity for cross-examination to the private defense counsel for the accused. No, who was absent, huh? On the said date, huh? Start. Miss, again, done ADPP. So what we'll do, instead of calling records,
No, sir.
no point calling record, because he is admitting that on that day, counsel was not present because of this.
Health.
Only the accused was present. Made a request to
Consider.
fix another date for cross-examination, probably you have met. So that was not allowed. So this involved, the witnesses includes the prime witness, the victim also. So it will be difficult. So let it pay some cost, because if all of them are from SEPA, you bear the expenses 5,000 each. 5,000 each. With that, will allow and send, allow, okay, we'll pass order. Okay.
To fix another appropriate date as per the convenience.
Yes,
That be fixed by trial court, my lord.
but then you'll have to appear, the accused have to appear with the application with this order, and then get the date fixed for the cross.
On next date,
Because next date is already
One,
fixed.
on one.
On the
it is
next
fixed.
date only,
I-
you can just apprise the
My
court
lord.
that this is order,
Right.
and next date may be fixed for the cross examination of these witnesses
Right.
report, and then, but you have to bear, and then you have to deposit the amount prior to that.
My lord. High level.
Okay, this will be disposed of. Then, okay. Disposed. Yes.
Your lordship, prior to that, your lordship, my brother has made a mention in the morning with regard to item number 6, your lordship.
Hmm.
The cause list that he's having and the cause list
It's bail,
we have, your lordship.
AB.
Yes, Lordship, bail application. Actually, I was supposed to mention item number 7, but due to the misprint of the cost list, I've mentioned item number 6. And
What is the name of item? You want to mention which one?
item number 7,
7 is the name. Can you read the name?
Sring Gombu.
Sering Bombu versus State.
Seringombu.
Versus State, yes, my lord.
Said you actually wanted to mention this one.
Item number 7, yes,
This is also bail.
yes.
No problem.
No issue.
So this, instead of item number 6, this orders would be for item number 7.
Obligation, obligation.
You are in the 6. 6, no adjournment?
No.
Okay.
Obligation.
Your Lordship, I want to withdraw this petition due to some technical glitch inside the
Item 2.
item number 2, yes. And please allow me to file again, na, for liberty to file again.
Yes, you have to. Because it involves the PDPP Act also. How can that be? Land Council for the petition.
Neelam
what name?
Talum, Neelam Talum,
Neelam Talum.
yes.
You just want to withdraw
Yes, yes, withdraw, and I will file again.
with liberty.
Yes,
Okay. Mr. Neelam Talum, Land Council for the petitioner. Prays for and allowed to withdraw this criminal petition with liberty to file afresh, if so advised. Stop. This criminal petition is dismissed on being withdrawn with liberty as prayed for. Okay.
much obliged.
May I, Your Lordship?
Yes.
Your Lordship, this petition has been filed under section 482 of CRPC, praying for quashing and setting aside of the FIR dated 2nd February 2024.
FIR.
Yes, Your Lordship.
Why FIR?
Your Lordship, this entire case has been cropped up because of the misunderstanding and non-communication on the part of the petitioner number 2.
No. What is the offense involved?
Your Lordship, in the year 2023, there has been some monetary transaction between the petitioners. And when there was no communication by the petitioner number 2, and when he, without any information, vacated the room where he was staying, the petitioner number 1 has lost FIR against petitioner number 2, because petitioner number 2 has promised to avail him a contract work of more than 50 crores from the central as well as from the state projects. And for the expenses for such transactions, your lordship, the petition number 2 has taken over the years more than 1 crore 90 lakhs and above money from the petition number 1.
So what was the agreement?
Your lordship,
What was the agreement for that payment of those? For legal or illegal purpose?
it is for legal purpose.
What legal purpose?
Because for the expenses, the petition number 2 has taken money from petition number 1.
Hmm.
But only because the petition number 2, without any information, he left the Itanagar.
What expense? For what expenses?
Uh,
You say you entered into some illegal
yes, your lordship.
agreement, paid, and used the state service for recovery. How can that be?
Your lordship, the petition number 1 was in the impression that petition number 2 has chipponed the money and defrauded him. But when the proper
Was it a
communication,
loan?
no, your lordship,
For what then?
it is for the project works, your honor, as promised by the petition number
The
2.
project belonged to the accused.
No, your honor, it was a promise to avail projects from the
That is
center.
why I'm asking.
Yes.
Whether the project belongs to the accused.
Till that, your lordship, no project has been availed. Your honor.
Hmm?
Till that, no such project has been.
Then it was illegal agreement only. Enter into such illegal agreement to do something which is not legally permissible. Yes. State. But it is in the state.
State of investigation, your lordship.
We do not know what more thing will come up after the investigation. How do we interfere with the investigation at that stage? If the case is still under investigation,
Your lordship,
how do we say stop the investigation?
this matter is strictly with against the petition number 1 and 2, your lordship, and the main subject matter of the
You see,
case
the
is with regard to the
case was
monetary
registered,
transactions.
see, 120V409. That is why I'm asking. If it is a loan, then it involves with the private only. Affect only the petitioner and the respondent or the accused. But then it appears that the transaction involves with certain some other things also. It appears. We do not know what thing will come after the investigation.
Yes, lordship.
At the investigation stage, how do we interfere? Let the investigation result comes out, and if it involves with the money transaction between only these two, and it doesn't affect the state, we'll interfere. We'll entertain your petition. So when the FIR was lodged,
FIR was lodged in.
how long it has been since lodging of FIR?
FIR was lodged in 2nd February 2024.
February.
Yes,
Not yet completed.
not yet completed.
So what do you say?
CD, we have to.
CD?
Yes,
But even if CD, if there is nothing, of course, that can be, but you say during investigation, it's very difficult to interfere with.
yes, yes,
It will amount to interference of the investigation. Which,
exactly, yes. And
which the court always try to refrain from.
it can be ascertained from CD only.
But even if CD, you want the CD, do you want the CD?
If your lordship remembers, the same, the bail petition of the co-accused are pending before this court, your lordship.
Bail application is also pending.
Pending, on the last occasion, if your lordship
Then
remembers.
Problem. Bail application is still pending. During the investigation, it's very difficult to interfere. Let the then let the investigation be completed. If there is nothing, you don't have to worry. Because you say that the party have agreed, now the party have agreed.
Yes, lordship.
Okay, then why to worry? The accused will be cooperated by the witnesses.
uh,
Now, at this stage, since the case is still under investigation, your witnesses will cooperate. Let the, because during the pending, if the bail petition is still pending, it will be difficult. Very difficult.
yeah, if I may, Lordship, the bail application is pending for other accused which,
So that is why, it is in the same case,
yes, Your Lordship.
then
And moreover, Your
it's too
Lordship,
early, it's too early,
a total,
premature.
some of the amounts has been already recovered, Your Lordship.
See, it is in the process,
Yes, Lord.
then
And the petitioner number 2, the
it
accused,
involves with the bank, it
Has,
involves with the person.
has
It
promised
involves with
to
the accused,
repay
and some
the
of the bail petitions are still pending. How do we set aside and pass the investigation itself, the FIR itself? And what will happen to the bail application? See, I think, you wait for some time and file a press.
Yes, Lord.
This is too early, premature.
Yes, Lord.
Okay. Mr. You are Mr.
B. Ganga.
B. Ganga, Land Council for the petition. Prays for and is allowed to withdraw this criminal petition with liberty to file a fresh if so advised. Mr. Tado, G. Tado, Lanet, additional PP, appear on behalf of the state staff. This criminal petition is dismissed on being withdrawn with liberty as prayed for. Okay.
Much obliged, Your Lordship.
Lord, in this application, my Lord.
Yeah.
It's an application under 482 and 439(2) for cancellation of bail because the bail was being granted on my ground that on perversity and on arbitrary
Cancellation
exercise.
of?
Bail, my Lord. That was granted on 26/2024. And
So what is the ground for cancellation?
no,
Is state
there are,
or
there, no,
private-
there,
state or private?
there are two things, my Lord. One is for cancellation of bail and one is to aside the order because the order that was passed was on perversity without taking into consideration of the relevant factors. The parameters, because it's a murder case, my Lord. It's a murder case and I have not filed the entire charge sheet because I need to file the entire charge sheet. Because in this particular case, my Lord, 3 witnesses who happens to be the sisters and son of the accused, they have given their 164 statement before the learned CGM. So this, out of these 3 witnesses, 2 have been examined, and they also have affirmed that it is their own brother who has committed a crime in 164 also, and even during deportation also, which I need to get a
Already-
certified copy.
Already evidence recorded.
Recorded. PW 1 and 2 have been recorded. And there are 2 other eyewitnesses. One happens to be non-Arunachali. The evidence yet to be deposed, my Lord. And moreover, the Planet PP out there has also placed on record that the accused is a constable, retired constable, and very influential. And there were occasions where he was given threat, my Lord. These factors were not considered, my Lord. The only your Lordship can come to a concrete conclusion whether it needs to be interfered or not, only after producing the entire record, my Lord. Because 164 statement clearly says that it is the father and the brother who has committed a crime. They have affirmed even before PW
Father and-
and 2. 2 sisters they have affirmed on
Yeah,
deposition.
It is the father and,
Their father and brother.
okay,
3 witnesses have confirmed it's their father because it was narrated to them by the father.
father and whose brother? Whose brother?
Accused father. Accused is the sister of PW 1 and 3. And his son also has given 164 statement yet to be deposed. So without taking all these factors, my Lord, the learned trial court, well, it is his discretion power, has granted a bail. So I have come here under 482 to set aside a quasi-bail order on the ground of perversity, illegality, and arbitrary, my Lord, which your Lordship will only come to a concrete conclusion after going to the entire court, my Lord.
No, you see, the bail is discretion.
Yes,
know.
I understand.
And
Yes,
unless once the bail is granted,
my Lord.
unless the accused violate the
No,
condition.
no, that, my lord, I back to reserve it. Even in the getting up judgment of the apex court,
Hmm.
if the factors, because the
Purposes
great,
you have to-
yeah,
you
yeah,
have to
perversity.
satisfy- you have to satisfy.
Yeah, I'll satisfy the perversity.
Yeah.
This is also under perversity, my lord.
Hmm.
I have also given my grounds of perversity and illegality. So which your lordship can come to a concrete conclusion only after perusal of the entire
Let us-
record, my lord.
let us-
So I will place the entire record. I have applied for the certified copy of the CT, charge sheet also. So which I may be allowed to place on 14 on the reopening or 15, so that your lordship can come to a conclusion that if the PS has occasioned perversity, my lord, your lordship may kindly interfere with that.
Call for,
My lord, your lordship may call for the record, or I may be directed to place the certified copy of the entire document.
yes,
Your lordship may call for the record, your lordship. Meanwhile, notice may also be given.
Because the trial is going on, I don't want, because skin
have
copy has to be
included
called
the-
for. We don't want to stay the trial also, my lord.
have included the accused also.
Yes, my lord.
Okay.
State of Arunachal and under the accused have respondent number 2.
Okay.
I'll take service, justice service, or I'll rather
Okay.
prefer for speed post, my lord. You'll not accept
Lord,
Last,
justice.
Mr.
I'm Mr. M.G. Singh.
M.G. Singh. Learning counsel for the petitioner. Stop. I have also heard Ms. T. Ginny, learned additional public prosecutor. State of Arunachal Pradesh. Stop. That. While filing this application under section 439(2), read with section 482 of the Code of Criminal Procedure 973, the petitioner is praying for setting aside the bail order dated. Bail order dated
26, 2024.
2024, passed by
Learned session judge
Session Judge, Lower Subansiri, District 0,
in
in
session case number,
session.
number Z. That
Wait,
my lord
where-
will find it
where
page
have you
15.
mentioned the case number?
My lord, your lordship will find page 15. There itself, page 15. Annexure A1, there's only one annexure. Page 15. Page 18, my lord, 18, sorry.
18.
Annexure A1.
Bail application number, passed in bail application number 27, 2024, within bracket Z, in session case, within bracket 0, number 03, 2023. Bail application is 27. Okay. Back. Call for the scan, we call for the
Scan copy, your lordship.
scan copy of the trial court report. Issue notice, returnable by.
My lord, as suggested by my learned PP, the accused, I may be served through the police station concerned.
Served through the concerned jurisdiction police station, your lordship, through the
So then it will be returnable by.
returnable on, as they have stated that they have some urgency, your
After
lordship,
vacation.
after vacation on any date.
That's any time that your lordship,
You want a fixed date?
I fix that, if your lordship is please.
No, then in that
50.
case, the
50.
reports, if fail.
Yeah, that also one
that-
aspect
that-
of the matter.
so we'll
Your
say
lordship, please, but
It will be listed after vacation.
After.
is your lordship, please, a date may be fixed anytime at that your lordship.
Date.
I fix that only.
22nd. 22nd? Oh, 22nd, your lordship.
22nd. Okay. Returnable by 22nd July. Since Miss T. Ginny appears on behalf of the state respondent. No formal notice need be issued to the state respondent staff. The petitioner shall take steps upon the respondent number 2 by
Through the jurisdictional
Pro-
police station routed through the office of the PPA.
through the jurisdictional police station, routed through the the office of the PP.
Yes, sir.
Okay. List this matter on 22nd. Okay.
Obliged, my lord.
Deeply.
Yes.
Your Lordship, may I submit?
Yes.
Your Lordship, this is a petition for quashing of the session trial, which is registered as 03/2024 under Section 8 of POCSO Act, led with 354A IPC. The order has not been reflected in the, since the instruction has not been reflected in the order, so they told me they cannot insert this page
What is that?
in page number 2
Two of
of the petition.
you have the page number 2 of the petition with you.
Yes, yes.
What do you want?
Now, motion was taken up on the last occasion. So today we have to call for CD, case diary.
Is that it?
Yes, yes.
Already charge sheeted.
Charge sheet. What is this for?
This is
Bail.
POCSO.
Yes, POCSO bail.
Okay. Also have Mr. Jeetar, Knowledge, Additional Public Prosecutor, State of AP, staff, Madam. This is an application filed under Section 439 of the Code of Criminal Procedure 1973 for praying for release of the accused, Sri Amit Thakur, on bail, who has been arrested by the Itanagar Women Police in connection with the where is the, sorry, POCSO, okay. In connection with the POCSO Act. Then have you made an application before the special court? Have you filed bail application, moved bail application before the special court for release of the accused?
Yes, it was done in session court earlier.
It was rejected.
Yes, yes.
When it was rejected?
Page 112.
What?
112. Rejection order.
Page
112.
1
112. 112. Last portion.
This was rejected on 74.
74.
Okay. So now the situation here, the status of the case has changed. Is charge sheeted. Okay. POCSO case, POCSO Act 04. I think this number may not be correct. This POCSO Act 04. 2024, arising out of the Itanagar Women PS case number 0324 under section 363, 366, A, 376, BA, 354A, 120 of IPC.
Sorry to interrupt, Your Worship. Sorry to interrupt. To change the course title, the petitioner counsel has to file IA.
He said that,
Expecting your lordship to type there, they will file an IA.
no, he will be, in the, sort of, he was allowed, no. As prayed for by the Rani Council.
The procedure is that you should file an
No,
IA.
no, that is there, but then he said that he was allowed.
Oh.
By which order you were allowed to
So
change the court title?
by this court itself, I was verbally allowed by my lord.
On 26,
Yes, yes.
but 26, no order as such.
It
As
was
prayed for by the Rani Council for the applicant, this matter again on so and so.
yeah, verbally it was allowed.
There was no-
February,
No, verbally it was allowed.
verbally.
Yes, yes.
Who?
By yourself, by my
By
lord.
this court.
Yes, by this court.
But they don't mean that you will have to file an.
Yeah.
appropriate application.
Oh.
If you want to,
Sir.
you see, amend, then you have to file application only. Because you see, on that they probably
Mm.
you had submitted that there is some defect, you want to correct it, or you want to file something, the IA for correction, etc. So it was allowed probably. So correction is not allowed here in this order. You file the amended course title first. Okay.
Hmm.
You can move it on first also. Will allow you. Okay. Non-counsel, okay. Non-counsel for petitioner, submits that. Mr. Non-counsel for petitioner, Mr. You are
M. Kambo.
M. Kambo.
Yes.
Some praise for allowing him to amend the submits that there is the case number. No, praise for allowing him to file IA to correct the course title of the bail application. The prayer is allowed. You file, will allow, and on the same they will issue. Okay. You file.
Yes.
Your lordship.
Yes. No. So agent when they file.
Your lordship.
Agent mention. So because he is praying, so let him file and this. Where is Mr. Kambo?
There is a notification now, my lord, how to do it. Earlier, your lordship used to allow by hand also.
By hand, no, now it was not allowed probably hand also.
There is a-
But
there is
because it has to be
notification.
replaced.
Yes.
And for replace, the order need to be,
You
so
have to file it.
this may be replaced, directing the registry to do the needful. So that is there, and he need to file.
Yes.
So when you want to file, if it is filed today, you can mention on the first also.
Yes, I will do today.
Hmm.
Ali.
Okay, list the matter on when, first,
Yes, short date may be given. Short date.
only one date, first, we have, before vacation.
Your lordship otherwise can, your lordship otherwise can direct that, once the implement is then accordingly the matter may be listed, your lordship, without any giving any
That is
specific date.
Okay,
If and when your
The li-
amendment is.
you file and mention, okay?
Yes.
As
I'll
and
file
when
tomorrow,
you
tomorrow
file,
itself.
the IO, it will be listed only, automatically it will be
Okay,
listed.
okay.
Okay.
Lordship, if may take item number 6, Your Lordship.
Yes,
Your Lordship, I have just been informed that he was not arrested, Your Lordship.
Hmm?
He was not arrested.
then in that case,
Uh, Entry may be made absolute otherwise, Your Lordship. Because in the event of arrest, it's given in the event of arrest, Your Lordship.
mhm. Okay, Mr. Thong, you are Mr. Thong. R.N. Thongan, Lana Council for the petition. So also had Ms. T. Jimmy, Lana additional public resolution for the state. Okay, stop. Para. This is an application filed under section 438 of the Code of Criminal Procedure 1973, praying for grant of pre-arrest bail to the accused applicant, namely Deepak Kumar Jain, apprehending his arrest in connection with the Itanagar PS case number 220/2023 under section 120B 420 IPC star. By an order dated 19/3/2024, while calling for case study, the accused applicant was protected by an interim order interim order with the direction to release the accused applicant with the direction that in the event of the accused applicant being arrested, he be released on bail on execution of bail bond of rupees 50,000 with one surety of like amount to the satisfaction of the arresting authority. So the accused was also directed to appear before the eye of the case staff. Pursuant to the said direction, the accused applicant appear before the eye of the case on 3/6/2024. And on his appearance, the IO has examined and recorded his statement under 161 CRPC. The planet additional PP produced case study, and I produced the same as per the record. The accused has already given his accused has appeared before the eye of the case and already given his statement under 161 CRPC. It appears that the accused is cooperating with the investigation of the case. Since the petitioner accused applicant has already appeared before the eye of the case and cooperating with the investigation. Cooperating with the investigation of the case. And well, the learned additional PP has no objection if the interim anticipatory bail is made absolute with its absolute in terms of the interim anticipated bail order dated 19/3/2024. So in view of the above, the interim order granted to the accused on 19/3/2024 is thereby made absolute, regularized and made absolute in the same terms and conditions. So this bail order shall be read along with the bail order dated 19/3/2024. So with the above, this bail application stands disposed of.
CD may be returned, Your Lordship.
Return to CD.
Lordship, along with the main petition, the IA may also be in terms of the,
In view of the order passed today in AB 60 AP 2024, this IA stands disposed of.
deeply.
Both are disposed.
May I please?
Yes.
This is a case, last occasion it was listed under.
Yes.
Last occasion it was listed under orders, like on mention it is supposed to come in admission list so that it can be heard. LCR has come. So matter is ready for hearing. If you can hear today, so otherwise date.
This is
a quashing of proceeding in respect to old case initiated in the year 2009. And last 5 years prosecution has advanced no progress. Despite there is an order by the Honorable Court to expedite the matter. Last 5 years prosecution has seriously failed to produce witnesses to prove their case. This is the only stand. And instead, Lord Magistrate is insisting the accused to appear in person.
so. What is this? What? Let us see the.
Yeah,
What is the offense involved?
420 minutes. It's a bank officer. Offense is cheating under the Indian Penal Code. 420. The petitioner is a bank officer.
Petitioner is
Bank officer. Now, in the meantime, he has retired. He is an officer of the rural bank. During his incumbency, allegations has came that he has misappropriated some amount. He was then FIR was lodged. One paragraph FIR lodged. Investigation was completed. Charge sheet has been
let
submitted.
us see the FIR.
Yeah, FIR is at page 19.
Yes.
No, sorry, Miller. FIR is at page 26. And it's a typed copy is page 27. This one paragraph FIR. With reference to the above, this is to bring to your kind cognizance that Sri L.K. Singh, the branch manager of APRB, Basar branch of
Page 19.
Yeah, Miller.
Yes.
Cognizance were taken in 2018.
In 2000.
18 Miller.
This is dated August 2008. FIR,
FIR of 2009,
which page?
page 27, you also kindly see. 26,
47?
27.
Okay, not 19. Twenty-seven is FIR.
Yeah, my lord. 26 is the formal FIR. 27 is the typed copy.
What is this annexure A?
Annexure A is my complaint to the authority. I was given threats at my house because of some hand loans.
Okay,
Some,
this is your FIR.
this is my FIR. And
Okay,
this is,
the FIR in this case
in this
you are
case, FIR is
seeking for
at page
quasi.
26.
is 27.
Yeah, my lord.
Okay, just a minute.
Earlier to this, there are two complaints before the police. There are the threats to me and my family.
Okay. No, we are concerned with this FIR.
Yeah, yes.
Okay, please. Complaint against so and so. Okay. With reference?
With reference to A above, that means complaint against LK Singh, so and so up to so and so.
I'm sorry to interrupt, madam, but this is a case where my garden friend's principal ground is the last 5 years prosecution has not been taking place. So I believe records have come.
Yeah, records.
Paper book will be prepared to show where of the last 5 years why this case is not police is not being done.
No, I will show few others
Yes.
for hearing, for the purpose of hearing. My learned friend is,
Paper book prepared
Yeah, no. it has
Not
to
yet.
be- Yes.
or need to prepare?
Yes.
my learned friend is saying, since everything is ready, let the paper book prepared, it will be hard.
Okay.
It's a normal course. Instead of when.
We'll do that then, we'll pass order then.
Yes,
For
it
preparing
has to be.
paper book.
That's all right, but what happened?
I was curious.
No,
to
you,
know what offense.
that are order may passed, but what I want to appraise is,
Hmm.
witnesses are not turned up, but learned orders will show, LSR has come, learned magistrate is insisting personal appearance of which is conducted in Alo.
He is accused.
Yeah.
Accused need to appear.
My lord, he can be represented by the lawyer.
Yes.
He can be represented by the lawyer under
In the
317.
criminal case, how?
Under section 317, he can be represented.
370?
Yeah. Under
Just a
section
minute. That
317.
is why I want to see the FIR
Yeah, FIR is,
with the reference,
Yeah.
reference to the. Thank you.
Mr. So-and-so has appeared a total sum of rupees 11 lakhs 30,000 in different accounts in style from APRB, Basar branch during the period of his branch managership in December 2008 and January 2009. This
Okay.
refers to later
This
number.
was those by.
It's by the
Okay.
the then branch manager of APRB, Basar branch.
Okay. So you want the paper book to be prepared?
Yeah, in the meantime, I may be protected because Learning Magistrate insisting my appearance in Alo. My lawyer
Now,
is there.
in the criminal case, normally the accused
When-
need to be identified by
No, no.
the witness.
That's all right. When prosecution is not producing witness last 5 years, my lawyer is there. Identification is not a question here. 317 is there. Under section 317, he can be allowed to appear to represent by his lawyer.
If
Well,
the accused,
some order, a judicial order
The
must.
appropriate application be filed by.
Well, it is filed. What I will show the orders.
Hmm.
Despite it, applications are filed, Learned Magistrate insisting personal appearance.
no, no, no.
Oh, no.
Have you
That
made an
will have to be
application before the
challenged,
trial court for dispense of your appearance?
Yes, madam. That
What
is
was
not-
the order passed?
Yeah, I'm sorry. Like, Elsar has come, you also kindly see. Order
Not even
dated,
enclosed with the petition.
Hmm?
It is not even enclosed with the.
Yeah, yeah.
petition. How to do
order dated, 23rd September 2021.
It's there? No.
Oh, Elsar has come. Elsar has come.
That's why, my lord.
No, not annexed here.
Eh?
Not annexed here. So then if it is in LCR, then since we are getting it prepared, this one, paper book.
Yeah.
So then in paper.
That's,
it come-
my submission is, I may be protected till the next date
So
of
make
hearing.
make application before there. before
No,
trial
I am,
court.
that is how I am saying. Despite my application, Learned Magistrate is saying, no, you come in person.
What order was passed?
Well, I am showing, that is how I am showing.
That's-
That
30%.
order is not under challenge before. your lordship.
That is my ground for.
How can your
Hey,
lordship
hey.
protect him now?
Well,
Had you annexed that order also, then on the basis of the prayer made, that this was also not considered.
my interim prayer is till the next date of hearing, I may be, the proceeding may be stayed, or I may be protected, no coercive action may be taken, because my lawyer is appearing.
No, no.
When 317 is there, I was to be allowed to be represented. And what purpose will, sorry, if I will appear in absence of the witnesses?
Mr.
G Bhol.
G. Bol, learned counsel for the petitioner. Also heard. You have for private respondent, Mr.
I am for respondent number two, Ms. Hage for respondent number one.
Okay. Ms. L. Hage, learned public prosecutor for the state of AP. And Mr. Vicky Pangan for the respondent, private respondent number two. Staff. The paper book
Yes, sir.
has been received, no, sorry, not paper book, the LCR has been received. The officer prepare a paper book and furnish copy to, copy each to the learned counsel for the parties. Who is to be, this is criminal, okay. And list the matter after preparation of the paper book and furnish and serving a copy each to the learned counsel for the parties on the date to be fixed by the registrar staff. In the meantime, it is provided that no coercive action shall be taken against the accused petitioner.
I'll cooperate. I am attending the trial. I also want the witnesses to come. So,
You have to, in the criminal case,
well, my
Yeah,
lawyer
in
is
any
appearing.
case, my lord.
Well, my lawyer is appearing.
Praying something that is not even put to challenge before Lordship. How
No,
can
not
prayer be?
interim. This is my interim prayer. My
till
challenge
till
is
the
to
till the
propose
next date,
interim.
till the next date.
But till the next,
Hmm.
I don't want, even I don't want to stay. Because once it is said, my case will further delayed. I must be protected.
Just a minute.
This is a case of 2009.
Let us see your prayer.
Yes.
Interim prayer. You can-
Interim prayer is for suspending the proceedings, my lord. How can that be?
It's, your interim is for
Yes.
suspension of proceeding only, not that one.
That's why I'm trying to point out. That order is not even.
But why you are making
Lordship.
prayer, which is not in your petition?
My lord, my prayer is to stay the proceedings.
Just now he said it's not his prayer.
No, no, no. My interim prayer. Your lordship can see prayer now 2, page 17.
This is now, my lord, it was not even considered on the first day. There is no question of consider in this prayer at this stage. Notice was issued long back.
That's what the proceeding of-
So we should get that notice.
Now we need to see,
Hmm.
we need to see the records.
Yes. Notice was issued way back on 21/12/2023. After 1 year, my lord. Wow. Whatever.
And probably if you are making this prayer, probably with, by annexing that, you need to make a prayer separate.
Yes.
Because there is no prayer. I thought that, no, there is a prayer. Make a prayer in the meantime.
Well, my prayer is interim prayer is to stay the proceedings.
No,
This is
that-
the, this is a,
no,
pro- this is a
no.
case out of 482 of the CRPC. This honorable court has vast power under that section.
In that case, we will
No,
argue.
then in that
Lordship
case, you have to
considered.
satisfy the court.
That is how I am showing that this is the conduct of the London Council. Instead of when the witnesses are not coming, prosecution has failed to produce, but I am directed to appear in person. Is it not failure of justice? Prosecution failed 5 years to produce witness, but where accused is directed to come, accused is senior citizen, he is a, and record will show,
But it is not before your lordship.
record will show he is.
But in a criminal case, you see, the accused need to appear. Whether.
Accused is appearing to his counsel.
That is the procedure, we can't change.
The procedure is also there. 317 is the procedure where lawyer can be represented the accused.
No,
Great
if
respect,
the
what is
accused
this?
need to be identified, then in the case,
Well, sir.
for that, you have to make an application, prayer.
I
If the
have,
court satisfied that his presence may not be required in this case, in the next state, for next 1, 2,
but
3
let,
occasion, they have done the prayer.
317
But then
says,
blindly this court, we do not know. Who
No,
are
I am
the
showing the
witnesses
orders
who are
passed
going
by,
to appear
I am
in the
showing the
next
order, LCR has come. I am showing the orders passed by London court below, how it is prejudiced to me. Witnesses are not coming.
Oh, my lord.
My presence
This
is
is not a
insisted.
village authority court.
Hmm.
If a dispense application has been filed and it has been
Yeah,
rejected,
this-
he will have to file a
No,
application
this
challenging
is
it. What
not
is it?
rejected. It is not rejected.
Dispense application.
Well, I am,
make-
you also kindly have a glance to one order.
No, no, just, no, just.
This is not done, my lord.
Just a minute. Dispense application, you have to file before the trial court.
Yeah, I am
Trial
fine.
court is the best court to know whether your appearance can be dispensed or not. Because he knows, the trial court knows.
Obliged, I
that
am obliged.
In this case, the identification of the accused may not be required. So accordingly, they will dispense. But this court would not know whether the
I am
identification.
in a better, my
That's
submission
it.
is better footing.
Hmm.
How? When witnesses are not turned up.
Just a minute. And if you think that that application has not been considered, then you pray before this court. With
Yes,
Hmm.
applications are considered. But order suppose the next day you have to appear in person.
See, that is the requirement of the
I
procedure.
mean, it must solve some purpose. Witnesses are not coming. Why? What is the necessity of?
Now we do not know next time whether witness will come or not.
I mean, this is my
How
entire.
this court will say.
But
be able to say.
LCR has come. This is my submission. This is I have produced all the documents. Witnesses are not coming.
That is
No, that is annexed.
It
It is also annexed.
Considered next date
No,
after
sir.
perusal of
Milord,
the records
Milord,
on consideration of
Whether-
the record,
whether
we will
witness
consider
are-
only, but
whether
now you
witness-
see. Now since the record has come. Let the.
Besides that, my annexers are already on record. From the annexers, it is clear that witnesses are not turned up.
For that we need to see the record.
That is separate thing. Why delay, so long delay has been caused. But witnesses are not turned up despite orders, warrants, available warrants.
I have no idea. We have to see the record.
It is under annexers.
Hmm.
I am filed an application. I have annexes documents.
Hmm.
Unable to put
Wait,
it.
wait. Deposition, there is you have an deposition also.
Yes,
Witnesses are appearing, then.
these are all witnesses appeared 4 years back.
Hmm.
Thereafter, they are
This
not
matter
turned up.
needs to be heard, my lord, and there needs a preparation of a
No,
paper.
but it's
book.
problem if
Let us not
my lord,
waste this honorable
if
court's
it is
time like this.
protected from any adverse orders, it will no way prejudice the prosecution or the malleable.
No,
So, we'll direct the paper will be prepared
Yes.
as early as possible.
But till
Okay. So
I,
this-
my lord, I may be protected till then because it will not solve the purpose. Witnesses are not coming. London magistrate asking to appear in person.
Trial court, that is the procedure. We can't change. Okay.
obliged.
Yes. Yes.
An application in, there is another case pending before this honorable court by BA number 45, 2024.
Just a minute. Huh?
Lordship.
This is unlisted. Must bail.
Yes, Lordship. Court
Yes.
had an application in connection with session case number 02 of the 2021.
This is what? Yeah, this is the copy.
Yes. Now only.
So there is you see, content of the documents from page number, these documents are not clear and legible, then how do we proceed with? How do we read? There is no type copy. No, when it comes to difficult, there is remarks.
Yes, Lord.
The documents on page 59, 60, so many pages are not clear and legible. So how do we read this? Why don't you annex the type copy? No, these are not legible. You can't do.
Yes, Lord. Then I may be allowed to correct the same.
You have to, I think that you have to annex the type copy.
Yes, Lord.
So that is normal practice. You are supposed to know.
Yes, Lord.
There is a remark there. Why they should allow? Because normally this file, and even if it goes
Yes,
beyond also, it is to be perused by the judge. And you may know, but then in your absence, you would also not know. These are not clear. And what is this? Authority letter attached in the bail application indicates that serial number 2 is subject to accepted by the honorable court. What is the authority letter?
Page number 35.
Page 35. This is regular bail.
Yes, Lordship.
Person is in jail.
Yes, Lordship.
Okay, so authority letter. Is it about 34? What is the wakalatnama?
Wakalatnama in last.
So probably here the jail authority signature is necessary. Seal and authority. Seal and sign. In wakalatnama authorizing the advocate.
Lordship.
In wakalatnama authorizing the advocate, probably the jail authority seal and signature also necessary.
Yes, that's required.
So that is not.
No, not signed it yet.
This is something authorizing like the power of attorney to file.
Yes, Lordship.
This is like a power of attorney, but then you see authorizing to appear in the court on his behalf, he has to sign wakalatnama, and since he is in jail, the jail authority's signature, sign and seal is necessary.
Is there no record?
It's not there. You can see.
Yesterday, when I moved to jail to sign this wakalatnama, along with authority letter.
You can just see.
Okay, Lord.
That is necessary.
This is the sign.
Sign is there,
Yes.
but it has to be signed in front of the jail authority.
Yes, Lord. This is the jail authority sign.
In wakalatnama?
Yes.
It's there, just see.
Is it?
Sign and the seal is there.
Yes.
Okay, okay. Oh, it's gone. Yes. So this, you have to annex the clear copy.
Let me allow.
Hmm.
And another similar situated person has already filed bail application before this honorable court.
Okay.
And by this honorable court on dated 24/6/2024, this last week, BA number 45/2024, whereby this honorable court directed that this is the order. Heard Mr. P. Kalita, Land Counsel for the appellant, also heard Mr. T. Genie, Land Additional PP for the state. The Land Additional PP submitted the scanned copy of LCR available at the moment is of April month. However, thereafter short more witnesses has already been examined. Moreover, some important documents, including the 164 statements of the accused and the disclosure statements made by the accused, which needs to be perused for consideration of this bail application, are also not available on record. Hence, pray that the update scanned copy of LCR may be called for. This is honorable court's order.
It was called for.
where is allowed, considered, the registrar is directed to issue a reminder and call for the update, scan copy of LCR and produce the same on the next date. As prayed for the Land Council for the parties, list the matter on 29/7/2024.
29/7. I think you have enough time before that.
Yes, Lordship.
So that this can also be placed along with that. 29/7.
yes.
You can file in the meantime.
Okay.
Withdraw it, file it. What?
No, I will correct the same.
Correct.
Yes.
You will replace.
Oh, yes, yes.
Will it be allowed?
If allowed, Lordship.
Similar situation, he has to file IA.
Since it has already been
Mentioning
registered,
the page,
it will
Lordship.
be difficult
Yes.
because you have already filed it, registered. It will be difficult. I think then for replaced, then you have to make one small IA.
Yes.
File IA. Okay. Mr.
G. Pokon.
Land Council for the petitioner prays for some time to file a IA for replace.
Yes.
Um,
Objectionable pages.
um, for replacement of the some of the unclear and illegible documents annexed to the bail petition. The prayer is allowed. Okay. Don't have to mention so many things. The applicant is the petitioner is at liberty to file IA. Okay. You file and then list on the, no need to fix that.
Yes,
Yes.
Because you have to file after filing only it will be
Yes.
listed.
it will be listed.
You file first, it will automatically be listed. Okay.
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 Abless.
Apology.